All right, my name is Andrew Burt. I am managing partner at Luminos.law. We are a boutique law firm focused solely on managing the risks of AI. And thank you for joining. So today I'm going to talk about the relationship between law and language models. Give me 1 second to make sure everything is set up. Okay, so we're going to talk about law and language models and that relationship. That relationship, as we're going to see, is a bit complicated. And in fact, those two are a little bit antagonistic in practice. And we're going to talk about that. We're going to talk about what to do. I should also say I tried very hard to come up with an acronym for this talk that would be LLMs. So hopefully we are off to a good start. All right. What is my thesis today? This is my thesis that laws will fail to regulate language models. When it comes to LLMs, the laws will fail. And so what do I mean exactly by that? First, what do I mean by laws? So I mean big national laws like the EU AI Act in the EU, national proposals here in the US, they're circling Congress. These are kind of the big ticket items. I also mean regulations from agencies, the Federal Trade Commission, the CFPB. There are lots of different regulatory agencies here in the US. And I also mean those types of regulations. And I also mean case law that comes from the courts, where the courts kind of handle these issues. One important caveat, I'm not talking about intellectual property. I'm not talking about copyright issues. I'm not talking about the data use restrictions that go into the data for training language models and their output. There's a lot of press about those issues, and that is kind of to the side in my view. So I'm not going to be talking about those when I talk about the law. I'm really talking about issues like privacy, security, fairness, transparencies, torts, injuries when things go wrong. And I'm hopeful that this distinction is going to become a lot more clear shortly. Okay, what do I mean by fail? This is actually something that I think is very important that we all understand. What I really mean is that these new and evolving legal approaches to risks of language models, they're not going to sufficiently address the most serious risks of language models. They're not going to address all of those risks. My main point is that even after current laws, as they're kind of being shaped, even after the laws have addressed the risks of language models the best they can, there are going to be failures. And those failures are going to be significant, at least the way things stand now. So my point is that if we look at the laws on the books, we're still going to be pretty vulnerable to language model risks as these language models evolve more, as they are adopted more and more over time. Okay, and then just for the sake of thoroughness, what exactly do I mean by LLMs? I mean language models that generate content, and I think very importantly, are subject to insane recent hype. I think everyone kind of tuning in has a basic sense of what I mean by LLMs, but for the sake of thoroughness, there you go. Okay, so this is my main point today. Laws will fail to regulate language models. I talked about what I really mean when I talk about failures. Now, here's what my second point is going to be. My second point is going to be more practical. It's going to be, frankly, what you as data scientists, engineers, technical personnel, what you should actually do when it comes to de-risking your language models from a legal perspective. So basically, if the law is not going to fully help you manage all the risks of language models, if it's not as clear as you really need it to be to comply with these new laws, what can you do? What should you do? Both about the risks and about compliance. So that's going to be the second point, and we're gonna get there. All right, let's start with the law part of the talk. This is a very basic, but I think helpful way to think about how the law works. This comes from the U.S. Constitution, Article 3, Section 2. This is the famous clause. It's called the Cases and Controversies Clause of the U.S. Constitution. And what this means generally is that laws require a harm either to rectify or to prevent. So courts can only basically take up cases if something bad has happened. And similarly, laws are really only going to be focused on preventing a harm or addressing a harm once it occurs. And so basically, this is not a talk about constitutional law, but I think this is a helpful symbol of the fact that in the law, generally, if there's no clear harm, it's very hard for there to be clear laws. So this basic proposition, I think, is very important. So now let's talk about digital harms and how harms arise in the digital world, which is much, much harder than in the physical world. And so, frankly, it's notoriously difficult. And I want to start by grounding us in an example with a privacy harm. And again, all of this is much, much harder with harms that arise from generative AI and language models. this picture comes from one of my favorite examples where Google took an image of the driveway of a family called the Borings in Pennsylvania in 2008. This was, 15 years ago. I also, I love the name of the Borings, but basically the Borings were extremely unhappy about this very blatant violation of privacy. I think they might have even had no trespassing signs up in their yard. So they sued Google. What exactly did they sue for? They sued for invasion of privacy. I think they also said this caused them, mental distress. But the question is, okay, so they were harmed. What's the actual damage? What is the actual harm here? Google fought the suit. They admitted to trespassing. The judge ruled in favor of the Borings. And then basically when you would say, it really counts, the judge awarded the Borings a single dollar. And so Google lost $1 in this lawsuit where they clearly did something wrong, but it was very, very hard to figure out what the actual damages were. So technically the Borings won. I would say for all practical purposes, and in any real sense, the Borings lost. So, 1 point for Google, 0 point for the Borings. Okay, so that's traditional kind of privacy concerns. Now let's kind of take this example and apply it to the harms that arise from generative AI systems. And so this comes from the AI incident database. This is a really great resource for anyone looking into AI incidents. The team there does just awesome work. And so this incident, we're going to talk through a couple as examples. This incident comes from a language model, basically making up fake cases, which were then submitted to court as part of legal arguments by a lawyer. So is this bad? Obviously, this is not great. But what exactly is the harm? When did the harm occur? Did the harm occur when the language model created the fake cases? Did it occur when the lawyer submitted that output to the court? Was the harm really that there wasn't kind of a warning in the actual submission from the lawyer? There was no clear disclaimer that some of this information was created by a language model, even if the content was false. Like, could that have done it? So what exactly is the harm, and how do we go about making that harm clear? Another example, again, from the AI incident database, people started using generative AI content from language models to submit to publishers, and that in turn basically degraded, some publishers would probably say ruined, their own submission management systems. So again, this is bad. Lots of call it extraneous misinformation, disinformation, bad content is floating around and taking the place of otherwise theoretically good content. Bad. But when exactly did the incident occur? Who did it harm? Again, these are very difficult questions. Here's another example. A prototype language model gave biased answers to users. So bias is obviously a very notoriously difficult issue. It's a cause of serious concerns when it comes to language models. So this is a major problem. Stepping back though, what's the harm here? Who did it harm? When did that harm occur? These are all deeply, deeply important questions if we're going to even have some kind of semblance of how the law is going to address these issues. So we can call these kind of informational harms. These examples are meant to show that language models are unique in many senses. The harms they create aren't really like normal harms. And we can think of these harms as being kind of bad information. They're not physical, they're not tangible harms. And of course, the fact that they're informational creates all sorts of issues. And so even if the consequences are huge, something like systemic bias, something frankly akin to environmental harms, to pollution, the fact is that they're dispersed. The people they're harming, the types of harms are dispersed. And for that reason, the responsibility for those harms is unclear. So is the responsibility on the user? Is it on the developer? Is it on the deployer? Where does the harm come from? At what point is intervention expected? When? We talked about this before. When exactly do the harms take place? Who, again, who does this actually hurt? Is it a person? Is it a group? Like, thinking about environmental harms, does this mean everyone is impacted, as in society at large? And kind of the bigger the umbrella of the people who are being harmed, I would say the more difficult it is to actually inflict damages. And again, like we talked about with the cases and controversies clause, kind of as a symbol for how the law works, the more specific, the more clear the harm, the easier it is for laws and regulations to address it. And in this case, if we're talking about collective harms, it's really hard to figure out what it is that we should be doing. And then, of course, we talked about this with the borings. Even if we can answer the above questions, how do we compensate the people who have been injured? Again, all of these questions are just extremely difficult in the case of language models. And because they're difficult, the laws are going to be pretty unclear, or I should say, not just pretty unclear, but not as clear as technical personnel, data scientists, engineers are going to need if we're all going to actually sufficiently address these issues. So we're thinking about these as informational harms. I think even broader, one of the even bigger challenges about this is that we can call these kind of harms that accrete. And what this means is there's no single point in time. Frequently, there's no single victim. A lot of the harms end up being collective and kind of societal. And so one of my favorite examples about this actually came from a client we were working with at the firm. It wasn't actually related to generative AI, but I think this is quite kind of symbolic. So basically, they were doing voice amplification for VoIP. What they needed to do was basically drown out background noise and increase the right voices to make the experience and the audio clearer. And so in any single conversation, there weren't major differences between male and female speakers, but they did some studies, and it turned out that kind of over millions and millions of hours of audio, it turns out that female voices were being dampened, male voices were being amplified at much higher rates. And so basically in any conversation, the difference was negligible, but over millions of hours, there was a very, very, very big differential. And so I think this is a good example of the types of harms that arise from language models, because in any single use, it's really hard to say this person was harmed or this harm is kind of so egregious that we need to take action. But over time, as the usage of these models increases, these harms become more and more clear and more worrisome. And so what is frankly, I think, most dangerous about language models from a risk perspective is that it takes a huge amount of use for these harms to really come into effect. And because of that, it's very hard for laws to address them. And so I tried very hard to try to incorporate some cartoon in the slideshow. This is the best that I could get. This is a Spaceballs reference. This comes from Pizza the Hut, which is itself a play on Jabba the Hutt from Star Wars. And even though this is frankly a pretty gross example, Pizza the Hut is built up over slices of pizza. And so the question is, when does this Pizza the Hut become an actual entity? Which piece is it that actually takes them from a pile to something that's actually a character? And so again, this is a very gross example, but the basic idea is that the harms of language models accrete, they add up. If you look at any single specific moment in time, it's very hard to say this harm is very significant, but if you step back, those harms become very clear. All right, so laws are starting to really deal with, at least focus on these issues. There are a host of laws already in existence that deal with them. To some extent, they're not as clear as they need to be. And so there are laws like the EU AI Act, which is really, really focused, obviously, on AI. We'll talk a little bit more about what the AI Act requires, but I think for now, it's important just to highlight that the penalties for violations are staggering. Fines can get as high as 6% of global revenue. So this regulation, which is expected to come into effect, I think in about 2 years, is really the fines and the consequences are going to be quite staggering. All right. So these are the high-level requirements I have kind of highlighted here in blue. So take a look at what I've highlighted. We're going to talk about them in more detail. I would just say right now they're quite high level, transparency requirements, some auditing requirements, and then some safeguards against generating illegal content. So very high level requirements. We're going to talk about this in more detail shortly. But I think it's very important to highlight really the depth of the problems that we need laws to help us solve. And so what are these problems? Basically, look at the harms. There are many, many harms we need to worry about when we think about language models. There's bias, there's toxic content, there's misinformation, hallucinations, opacity, automation bias, which is when people over-rely on these models. They trust them too much and then make mistakes. There are frankly just so many different risks that come with language models. And so we have these very, very important and difficult questions, questions that I'll argue laws are not capable right now of helping us address in practical terms. So some of those questions, not all, just some: what level of bias is acceptable in language models? How transparent do the actual models need to be? What does, frankly, transparency actually mean in practice of a language model? Is it explaining how the model works? Is it explaining how any actual output was generated? There are frankly a whole host of questions about transparency in these contexts, and it's just not clear. And then we also have this very important question, which is how much hallucination is actually acceptable. And so there's how much hallucination, that is information that's incorrect, is acceptable in a given interaction with the user. So, one interaction with the user in a language model. And then is there something different? Are there different standards for all interactions across users? Similar to that VoIP example I just kind of talked about, where in any one specific interaction, what goes wrong might be negligible, but over time, we might be able to step back and look at what's going on, and it'll be actually very concerning. And so we really need to find answers to these questions if we're going to get this right, if we're going to be able to adopt language models and actually manage the most serious risks. And so this is my contention, this is my argument, and we're going to talk more about specific details for how laws are addressing these issues. But the fact is, and my opinion is, these laws don't yet help us with the most serious issues that are coming from language models. Those questions I raised before, what amount of bias is okay, what transparency really means in the context of language models. These are all questions that we're going to need to address if we're going to actually manage these risks. And right now, I think the laws need a huge amount of work if we're going to actually address and hopefully prevent or minimize these laws. Okay, so that was my first point. I now have an asterisk because I want to make it very clear that I'm not saying that the laws will have no impact. I'm not saying that they will fail entirely. What I'm saying is that as it stands, the laws will not be satisfactory. They're not going to achieve their aims. More work is needed. And that's point one. Okay, point one, laws will fail. Asterisks to regulate language models in the way we need them to. Second point is, what should we actually do about it? That is a very good question. It is not actually the subject of this talk because the answer is we need to fix the laws. We need to improve them. We need to make sure that as they evolve, as they're implemented, they're going to do a lot more to address these risks. So that is another talk. This is not a primarily legal talk. This is a talk focused on what we actually do from a technical perspective, the way things are and the way things look like they're going. Okay, so for now, we're going to talk about what you, practitioners, data scientists, technical folks, should actually do. And so our second point here is going to be a practical one. As you watch all these new laws and languages, new laws and regulations emerge, the question is, so what should you do about that? And to do that, we're going to talk about a few more specific examples of how laws are approaching these issues. All right, so let's kind of revisit the EU AI Act. Again, these are kind of helpful requirements that generative AI systems need to have basic transparency requirements. That means disclosing the content was AI generated, helping to distinguish deepfake images from real ones. I assume that's also going to apply to language models, and ensuring illegal content is going to have some safeguards against it. Exactly what that means in practice, I don't know. I suspect that there'll be more kind of details and guidance over the coming years. But I think that highlights, even there, just safeguards against generating illegal content. I think that highlights the difficulty that laws right now have with these types of models. Okay, so there are a lot. I mean, the EU AI Act is there are huge number of details. There are like, I think, hundreds of pages of commentary and the law itself. So I'm not going to dive deeper into it, but at a high level, we see these very broad requirements, and then they're actually, frankly, really, I think, quite good templates for risk assessments in the Act as well. But again, the details we're going to leave to another talk. Here in the US, we have the Federal Trade Commission weighing in. So right now they're looking at major AI risks through really three main prisms: competition, deceptive practices, and traditional anti-discrimination laws. These are the places, the areas of law where they have the most power. And the drumbeat on AI risk is really getting louder from the FTC. They are focusing more and more on these issues. they're really sending the message that more oversight is coming from them. They're really, frankly, coming after AI. This comes from the awesome team at Gradient Flow. They put together some charts I'm just going to reference today on how the FTC is actually thinking about these issues. And so here, there are basically 7 categories of specific kind of harms and processes around AI development that they look at. And again, these are really, really quite high. I should say these are quite high level. It's not necessarily as high level as the EU AI Act, but it's still quite high level. And that means that in practice, when they start to enforce laws, when they start to apply their expectations against the actual deployment of AI systems, it gets pretty messy. And I think a very good example, a testament to that messiness, is their civil investigative demand letter that they sent to OpenAI. So basically, the FTC is engaging in some pretty stringent oversight for OpenAI and the models it's deploying. And again, the awesome folks at Gradient Flow basically broke down that letter. They turned it into this graphic. And what you can really see, I'm not going to go into the details, but what you can really see from this graphic is it kind of looks like throwing spaghetti at the wall. They're leaving no stone left unturned. They're looking at almost every single aspect of how OpenAI, gathers training data, actually trains the models, deploys the models, who uses them. It's really, really, really nuanced. And so I think this is a testament to the fact that in the app, they're looking at these issues from a very broad lens. And what that means is that when they actually go in and apply some oversight, they get extremely, extremely detailed. Again, kind of like throwing spaghetti at the wall approach, because the general harms they're looking at are pretty high level. And so it's not just the FTC, all sorts of different regulatory agencies, regulators, legislators, state level across the country. Everyone is looking at these issues, and everyone is really, I think, trying to rein in AI systems. And frankly, everyone is, I also think, struggling with all the issues we've talked about today. I also want to note that I've been really focusing on the US, on the EU. There are ways that I haven't covered here today to regulate language models. And I just want to talk about what they're doing in China, because there's one approach which is even broader than what I've been talking about. You can basically say language models should not generate content we don't like. And so there's a regulation in China, it's relatively new, and it basically says, actually, I think this is the actual wording. It says, language models shall not generate illegal content such as false or harmful information. So that comes from the actual regulation. This is a very high level approach, basically saying, hey, language models, don't do things we don't like. It's very interesting. It's largely kind of similar to the way that you might regulate speech, which is, don't say bad things. But there are a host of very major issues for this. I don't actually think this type of regulation would fly in places like the US. I don't think it's practical for our own kind of legal standards. But also, I think just from a technical standpoint, the problem is that language models are probabilistic, and that means that some percentage of output is not going to be as it's intended. And so if the laws basically say you're not allowed to do anything that is harmful or whatever it might be, it's not, I don't personally think, and from what I understand, there's no real research that can testify or that can guarantee that this type of content is not going to be generated. It can be minimized, but banning it, I think, is a huge issue, and one that makes it impractical to really adopt these systems at scale. Okay, so I thought that was very important. There are other ways to do this, and I wanted to make sure that we address those. So, all right, back to the approaches that we've largely talked about today, the US, the EU, elsewhere. When we look at the way these laws and regulators are approaching these issues, we can step back and we can basically say, this is the toolkit that these laws are working with. And so at a high level, this is really what they have. This is what they can bring to bear. So they can say, you need to perform audits on or risk assessments on your language models. You can say there need to be different type of transparency requirements. So we got a hint of this in the EU AI Act. When users are engaging with these models, they need to have certain disclosures. They need to understand at a basic level how the model's working. There are also data use restrictions. This relates to the IP, privacy, copyright issues. If you have specific data, you can't use it, or you can only use it for these purposes. There's public disclosure. So let's say something bad happens. you might need to report it. That's very common in the world of information security. Or before something bad might happen, you might need to disclose, this is how we're preventing it, or this is how we're thinking about it. That goes, that's quite actually similar to the risk assessment part above. And then, there's follow best practices. Again, this is quite common in the information security world, where you look at standards. Sometimes, lawyers might call them, or courts might call them, reasonable standards. But the idea is you have some grouping of best practices and you follow that. And if you depart from it, liability might ensue. I would just kind of give a plug here for the NIST AI risk management framework. I think that really is shaping up to be the central way to comply. I should say the central way to demonstrate best practices in managing the risks of AI. So for folks who aren't familiar with it, go take a look. It's the NIST AI risk management framework. And then lastly, and this is very important, don't lie. So basically, there's so much hype for marketing. There's so much hype just in the market around these systems. It's very easy to exaggerate the capabilities of these systems. And so laws can basically say, don't lie. Don't say your systems can do things that they can't actually do. Okay, so that's the toolkit. That's basically what the laws have to work with. That's a high-level sample of how the laws are shaping up. So given all of that, what should you actually do as data scientists, as kind of technical practitioners, given how hard a time laws are having? What do you do next? What do you do tomorrow when someone says, you're building a language model? What are you doing about the risks? All right, so I'm going to start with 3 main recommendations. I'm going to try to keep this as simple as possible. I'm going to try to distill the advice that we give our clients. So the first, get ready for legal oversight. It's coming. I hope that's clear from today's presentation. And what that really means is you should be standardizing the way you think about and document and test for risks. It does not have to be perfect. What you don't want to do is be caught off guard when legal oversight comes in, when lawyers need to review what you've actually done to manage the risks of your systems. And so documentation is really, I think, the best place to get started. So number 1, standardize the way you document your models, standardize the way you test, standardize the way you think about risks. It does not have to be perfect. If it's standardized, you're already ahead of the pack. All right, number 2, be transparent with users. And so there are all sorts of different ways you can think about transparency. I'm not advocating kind of getting really into the weeds and how exactly do you need to describe how the model's working or what's in the training data. What you really need to do is let users know when they're interacting with AI. That's it. If something goes wrong, you should also let them know. But you don't want any users to be surprised that they're interacting with a language model. All right, point number 3, don't lie. I talked about this in the slide before. It seems simple, but the fact is there's just so much hype around these models that it's very easy to let folks get carried away, and you don't want to let that happen. Look at your contracts, look at your policies, look at descriptions of the language models you're providing to customers or putting on blog posts. Make sure everything you say publicly actually aligns with what you're doing. Make sure all of the capabilities of these language models are actually reflected in what they're actually capable of. So basically, don't say things publicly that are not true with the actual models themselves. Okay, if you're able to do these 3 things, you're basically going to be in good stead with the laws as they exist now and as they are shaping up to be. And then I'm going to add in 2 bonus points. If there's one thing that's clear in this talk, it should be that language models have really a tremendous potential to cause real harms, and that the laws care deeply about these harms, and yet the laws are going to apply to them in a messy way. It's not going to be clear how you can make sure that you're complying with all the laws on language models. And so in addition to those 3 points before, I recommend you find a lawyer. I recommend that you make friends with them, and I recommend that you be ready for legal issues so you're not surprised when issues do inevitably emerge. And with that, I'm going to end. Happy to take any questions. Thank you for tuning in, and my contact information is here on the slide. So thank you.